I know several lawyers who seem to always get great results when they go into a mediation. But if I were to ask them to go down to the courthouse and try and make those arguments, I think they would struggle.
Hostility is something you might have when you first start a trial, but it's not a good thing for mediation because you want everybody relaxed and friendly, and you don't want anybody to think that settling the case is losing or giving up something that they shouldn't.
Sometimes your strategy is not necessarily to settle the case. Sometimes your strategy is to go down there and just see how far will the other side go and give you a sense of where you think they might go at a later date. Or, hey, I'm Tom Morgan with the Morgan Law Group, and in this episode of Trial and Error, me and my father are going to be talking about mediation, what goes into it, the mindset, the aspects of it, and what it does overall, as well as discussion of having a bench trial versus a jury trial. Check us out.
I agree wholeheartedly. There's two other areas that I wanted to be sure that I touched on and kind of asked you about. I suppose we'll take the first one. Explain what mediation is and what's the difference as far as I refer to practicing law when you're a trial lawyer as lawyering. What's the difference in the lawyering experience of mediation versus trial lawyer? In other words, first, what is mediation? And then secondly, is there a different mindset, preparation, and personality involved in mediation versus trying a case in front of the jury?
Okay, I'll give you my opinion, and then I want to hear yours, because my opinion is there are definitely a different mindset in going into each of them. I know several lawyers who seem to always get great results when they go into a mediation. But if I were to ask them to go down to the courthouse and try and make those arguments, I think they would struggle because it's the environment. I think it's more controlled. You also know, so in a mediation, you're going into a room.
First, maybe you better explain what mediation is.
Yeah. So
people have a understanding. Trial, there's a jury, and a jury brings back a verdict. But I'm not sure they know what that is.
Right. So mediation essentially is each side is going in and meeting with a mediator who's a neutral and presenting their side of the argument of the case. And they can say as much as they want or as little as they want.
Do they present witnesses?
No. So it's the clients only with their representative. So as a plaintiff, you're generally down there with your client. You as the lawyer, you and your client. The other side is usually the insurance company representative and their defense lawyer.
How do you present evidence then if there's no witnesses?
You're not presenting anything. You're presenting your statement of what you believe the case is about. You're going to give a summary of what you think over time, if discovery's been completed, what that amounts to, if it hasn't been done yet, what you think these people are going to come in and say.
So you just simply tell the mediator, I have an expert who's going to say this, and I have a witness who's going to say that this is the damage that came about, and this is another witness. This is the first time that I ever noticed this damage, or whatever the case may be.
Well, generally, you're doing a mediation. The other side sort of knows who the players in the game are. They may not have talked to them yet. They may not have taken depositions of them yet, but they probably know who your players are. So on each side, so they know you have this engineer, or that you have a roofer, or that you have a medical doctor, or so-and-so. So you're going to go in there, but you're not. You may present documents if you want. You may do a presentation, PowerPoint presentation
or demonstrative evidence.
You can do those things, and sometimes you do it. I mean, in a personal injury case with a large degree of injury severity, you might want to do those things. In talking about insurance claims, generally everybody's seen the reports. They kind of know what the property is. They know the outlay of where the aspects of the damages are. You don't really have to get into that as much. But what it is it's a short summary of your case. The other side gets to give their short summary of rebuttal. And then you break up into rooms separated, and the mediator goes back and forth and sees if he can coax each side to come to some middle ground.
Where's the lawyering come in if you just go down there and say, I had water damage in my house and it, overflowed and broke some pipes and I had $50,000 of damage. Where's the lawyering?
So the lawyering is in that the process itself, in my opinion, is a different mindset, because you tend to go in there with a strategy and figuring out how you're going to get there. And sometimes your strategy is not necessarily to settle the case. Sometimes your strategy is to go down there and just see how far will the other side go and give you a sense of where you think they might go at a later date, or the sense of, we know that this is a case that will not resolve in any manner without ever going through a trial.
So sometimes you're laying the groundwork for a future resolution.
Sometimes you're doing that. Sometimes you're just trying to figure out, is there a possibility that this case might ever be settled?
I see. And now the mediator, unlike an arbitrator or a judge, he can't make a ruling or tell either side they have to settle or take this amount or not take this amount.
No. The point of the mediator, as you know, is he's usually somebody who's a former judge or lawyer. He's going to come in there. He's going to try, as he talks to each side, give the pros and the cons of their particular side, where he believes it should fall, if he's got experience in that area. A lot of times he may say, look, the information they're giving me when I do this caucus, which is, breaking off with each side, the message I'm getting from them is they're here to pay something, but not where you want to be.
Now, mediation's been literally in existence your entire practicing career, hasn't it?
So mediation was in existence, but like you said, it wasn't something that was every case. A few years into my practice, the courts mandated that mediation become mandatory. So now every case has to be mediated at some stage before it can go to trial.
Okay. What I see in the development of mediation is that I'd practiced 25 years before mediation came into existence. And the lawyers attempted to resolve the cases on their own with phone calls, or as we mentioned earlier, you'd meet at the local bar, Sally Russell's, if you were in Dade County. There was a place down the street up in Fort Lauderdale. And you'd, try to kind of buttonhole the other lawyer and feed him some information. And it might take you several meetings and contacts with him on and off so that you could get the information across to him that he would push on to and convey to the insurance company, or if it was the other way around, to his client, to soften him up to settle. When mediation came in, I think I wasn't alone in so far as I looked at it with resistance, that it was a waste of time. I thought that it did nothing that I wasn't already doing and that I couldn't do better. I certainly knew more about my case and how to try my case than a mediator who was going to tell me what the weaknesses were and the strong points. And that's what the mediators, what they initially did for many years, good 10 years, was all they did was beat down your case if you were the plaintiff. If you were the defense, they beat it down or tried to tell you how it was a bad business decision not to spend money and settle the case because it was going to cost more to pay the lawyer. Here you're the defense lawyer, and he's telling the insurance company that they should take the money out of your pocket and give it to the plaintiff, who everybody doesn't like. Or if you were the plaintiff's lawyer, he was berating you right in front of your client, telling you this was her. And you're saying to yourself, what does he know? He's never been in a courtroom. He's somebody who just went to some seminar and got a license that allows him to be a neutral that is nothing more than a Roman messenger bringing a message from one side to the other. And that's why they killed the messengers, okay? Because the Roman legions could do it better themselves than sending a messenger. After a long period of time, developed an appreciation for the mediation for a lot of reasons. One, and I found some bad things about it. One, I found that we as lawyers, plaintiff or defendant, avoided discussing resolution until mediation because we knew we were going to be there. And when we got there, we really wanted to make an impact for better or worse, be it we wanted to lay the groundwork for a future settlement, or we wanted to see how far we could get, or we wanted to learn something about their view of our case. So I always looked later, and I'm saying this, mediation was mandatory by the time I developed an appreciation for it. I was always looking for at least these three things. Yes, hopefully it could get settled, but two, could I get a sense of what they thought the value was, not what the mediator said, but what the other side said, and where or how far would they go, and how did they view maybe some piece of evidence or maybe my client's testimony or something along those lines. And then I also felt that it was a good place you could hide behind the mediator who could go over, you could plant certain concepts that you wanted taken over. Tell the mediator something about the defense case that you knew that he would take over and tell them that might aggravate them or put a thorn in their side and, they didn't like hearing. So you could use the mediator as a buffer. But then I also realized that the mediator was human and not to be somebody who could be trusted. And that is a very difficult thing when with one side of your mouth you're trying to buddy and take him into your confidence, and then sometimes have to actually say, but you can't tell them this I'm telling you a confidence, and you're really not 100% certain whether they were honoring that or not. Now, later on, many years later, I actually did get certified in mediation, and they're not supposed to. When you tell them, quote, this is something in confidence that you cannot tell the other side, they're not supposed to. But like anything else, the mediators are in their own contest, and their contest is to see how many cases they can settle.
Right.
This gets them business. This gets them favoritism with the judges. This gets them some degree of notoriety, especially the bad cases. And everybody has, their bad case. We've got some in our office, cases that we have, and we know if it ever comes to the fact that we have to stand in front of 6 jurors and explain this case to them, okay, that we're going to do it with, biting our tongue, because there's no way we can find 6 crazy enough jurors that are going to give us money for our client. So it's got to settle at mediation. So those few mediators that are able to settle the dog cases, as we say, it's nice to know who they are. So the attitude that I have when I go to mediation now is totally different. And my preparation is much friendlier. Initially, it wasn't. I was very hostile, and I learned to get over the hostility. The hostility is something you might have when you first start a trial, but it's not a good thing for mediation, because you want everybody relaxed and friendly, and you don't want anybody to think that settling the case is losing or giving up something that they shouldn't. Whereas when you have a trial, there's no question you have a winner or a loser when the jury comes back. You can't cover it up, okay, by saying, hey, look, we played a great game, but we're going home with no money. Sometimes it's better to play a terrible game but still win, because that's what gets you to the World Series, is the wins. So the mental attitude is clearly different, and the preparation.
Yeah. I mean, what you said about the game, I mean, clearly, in my mind, whenever I went to trial, it was a competition.
Yes.
It was 100%. It's me versus the other guy. I don't care how good or bad my case is, but it's a competition. I want to win. I want to win, and I want to be able to pump my chest afterwards.
And you're trying to be the star of the courtroom versus being a star is not so important in mediation.
Correct. And so, but it's the lawyers that have a knack for mediation are the ones who also do some of the things you talked about in preparation. They're working with the client to soften them up, to understand that this isn't a win-lose situation. This is a negotiation, and see if we can get to a compromise, because it might be in their best interest to walk away with something versus nothing later on. Or what the toll psychologically or physically is going to be waiting the period of time to get to the trial, right? So
do you think that when you settle at mediation that you're doing a disservice to your client because maybe they're going to get less money than they would have potentially gotten at a trial?
No, I think sometimes you look at it and you think that way, but the grand scheme of mediations is everybody's agreed sort of what that number is, and that the outcome is better that day than taking the risks. That's why the lawyers that have a knack for mediation, like I said, they're not, you put them in a room with full of people and they'll freeze. But you put them in that situation where they can control the environment, where they know they only have to really talk for 15 or 20 minutes, and then they get to sit with the client in a private room and only deal with the mediator and kind of give those nuggets of information.
As I like to say, they're talking in whispers.
Right.
So they're taking you into this false confidence.
But they're the ones who know what they want to hold back and see whether they have to use it later or they don't want to use it. Are the ones who tend to get much better results at the mediation than you even expected them to get.
So there is an art form to mediation just as much as there's a different art form to the trial.
Listen, and there's an art form to the negotiation. When you are putting numbers out there and they're giving you offers back, there's a game in regards to figuring out where does it look like they want to be? How much money do you think they came to the table with? They're also trying to gauge how strong does the plaintiff think about their case? How quickly are they moving off their number? So there's a lot that goes into it.
I want to just sort of throw out, I'm not sure that, and I'm sure you faced it at least once or twice. Several mediations that I had that I would say resulted in a successful resolution took an entire day. Actually, they went partially into the night, but the first half of the entire day got sort of misdirected, intentionally or otherwise, on something that wasn't so important, but maybe was important. Maybe on a coverage issue, that sent everybody off looking and doing things in different directions, trying to resolve before they ever got down to talking dollars and cents. And I found that, especially in very difficult cases that had sensitive issues, that strategy of wearing everybody down to getting tired to where they invested so much time, maybe 4 or 5 hours into the mediation, that when they finally got around to talking money after that they'd invested so much time and energy into the mediation that they were more encouraged for a successful resolution than they would have been if you'd immediately started talking money in the first hour and found out that you were way apart and everybody packed up and went home.
Yeah, I mean, the mediation a lot of times could go off in a strange path. I mean, I've been involved in those. I mean, you early on sent me to a number of those that I'd be at all day.
So the lawyer needs to be prepared, because he never 100% certain that's the way it's going to go when he shows up.
Agreed.
Okay.
Okay.
I certainly, before our nickel is up in the machine here, there was one other thing I wanted your view on, and to see how, if any, it's changed, recent versus in the past. We'll call more my era of the past, and that is the jury trial versus the judge trial. The firm now, is everything a jury trial or a judge trial, or is it a 50-50 split?
There's almost nothing we do that's a bench trial. I mean, it's just the nature of the area of practice. We don't do it. I mean, I used to do a lot of bench trials early in my career because those were PIP cases, or not PIP cases, but property cases involving disputes over the valuation on cars and so forth. But it just, in my mind, the client, if we're going to go to a trial, the client wants their day in court. They want a jury, and that's what's going to get you the best result.
Well, why can't the judge come to the same resolution? He's supposed to be experienced. He's been on the bench a number of years. Why he's supposed to know the answers to these questions?
The knowledge is there. The problem is that he's there. You get a judge who has seen this before. He's not the emotional aspect of it is gone. There's no connection with your client in most parts. It's very hard to create that with the judge. The judge is going to want to streamline the discovery. It's a whole different style of a case being tried when it's just a bench trial versus a jury trial where you're putting on a show. You don't do that with a judge. It's a whole different animal and in a different bubble.
Is when you have 6 people, I mean, obviously you can't predict what 6 people are going to do, but I guess, at least I always thought, it's a lot easier to alienate one person who's the judge to go the other way, or that he may have some preconceived idea of, quote, the kind of case that you're trying to present, and therefore, you've already been cut off down at the ankles, and you're climbing up the ladder with one foot. That's disabled.
But that's why I enjoy having the former judges as mediators. I think that you get that argument there and the information out, but the bench trial is it's too difficult. So
does touching on one of the other things we talked on earlier, because they are, for the most part, jury trials when they can't be resolved, does that assist you in being able to get a fair trial for your client in other areas and other jurisdictions? In other words, let's say Pensacola versus Miami, where you're certainly going to get a different jury panel,
right. Definitely.
But if it's a jury versus a judge, is there some balancing because it's a jury?
I think you're trying a case in a community where that person, your client, is from, you're getting a better response than with a bench trial. I'm Tom Morgan with the Morgan Law Group. I want to say thank you for listening to this podcast of Trial and Error. If you want to find out more, or you want to check out more podcasts, go to our website, policyadvocate.com, and stay tuned for more podcasts in the future.